Item 1.01. Entry into a material definitive agreement. On March 17, 2022, Gevo Incorporated entered into a fuel supply agreement with Delta Air Lines Incorporated, pursuant to which Gevo has agreed to supply 75 million gallons per year of sustainable aviation fuel to Delta. Under the agreement, Gevo expects to deliver to Delta fuel produced at Gevo's fuel production facilities that are currently being developed. Delta will pay Gevo based on an index price, plus an additional price per gallon. Under the agreement, the parties allocate between themselves certain environmental attributes generated in connection with the fuel. The agreement terminates and replaces the fuel supply agreement dated December 11, 2019 between the parties. The agreement became effective on March 16, 2022 and will continue in full force and effect until the 7th anniversary of the date upon which Gevo notifies Delta that Gevo's production facility has achieved commercial operation and is able to produce and deliver the fuel pursuant to the agreement, unless earlier terminated pursuant to its terms. The parties may terminate the agreement in the event that certain conditions precedent related to the financing and development of the fuel production facilities are not met, or if certain customary events of default or other circumstances occur and are not cured within a certain time period. Upon the termination of the agreement due to an event of default, the non-defaulting party will be entitled to remedies at law or equity, subject to customary limitations on liability contained in the agreement. Such remedies may include covered damages for replacement fuel, which could be significant. The agreement contains certain customary representations, warranties, covenants and confidentiality provisions, and also contains mutual indemnification obligations. All fuel delivered by Gevo shall meet the quality specifications established in the agreement. The foregoing description of the agreement does not purport to be complete and is subject to, and qualified in its entirety by, the full text of the agreement, a copy of which is attached hereto as Exhibit 10.1 to this current report on Form 8-K and is incorporated herein by reference. Fuel Sales Agreement. This fuel sales agreement is entered into as of March 16, 2022, the effective date, and is made by and between Gevo Incorporated, a Delaware corporation, seller, and Delta Air Lines Incorporated, a Delaware corporation, buyer. Each of seller and buyer is referred to herein as a party and collectively are referred to herein as the parties. Capitalized terms not otherwise defined in this agreement shall have the respective meanings assigned to them in the general terms and conditions, as defined in Section 1.1 below. Whereby the parties agree as follows. Article 1. Scope. 1.1. Subject to and in accordance with the general terms and conditions that are incorporated herein by reference and attached hereto as Annex I, the general terms and conditions, seller agrees to sell and deliver or cause to be sold and delivered, and buyer agrees to purchase, pay for and receive, or cause to be received, the fuel for consumption in buyer's aircraft as detailed in the location agreements. 1.2. The parties intend for this agreement to replace that certain fuel sales agreement, the 2019 FSA, dated as of December 11, 2019, by and between buyer and seller, in its entirety, and, as of the effective date, the 2019 FSA is hereby terminated and neither party shall have any liability or obligation thereunder. 1.3. In the event of an irreconcilable conflict between this fuel sales agreement and its annexes, and unless expressly stated otherwise, the following rules shall apply. A. This agreement shall prevail over its annexes, save that, if Annex I addresses a topic not expressly addressed in the agreement, then Annex I shall prevail in relation thereto and its provisions shall not be diminished by the agreement. Subject to the foregoing, to the extent that this agreement supplements the requirements prescribed in Annex I, no conflicts shall be deemed to exist, and the provisions of this agreement and Annex I shall be read cumulatively. B. This agreement and Annex I shall prevail over Annex II and Annex III, which shall be subject to the terms of this agreement and Annex I. 1.4. All headings and titles in this agreement are used for editorial facilitation and shall not be interpreted as affecting or influencing the meaning, content or substance of its provisions. 1.5. All annexes to this agreement shall constitute an integral part hereof and shall further be subject to the terms of this agreement. Reference to the agreement shall be understood to include reference to all its annexes and any active location agreement, whether or not explicit mention thereto has been made in other parts of the agreement. Article 2. Affiliated companies of buyer. For the purposes of this agreement, the buyer affiliates set out in Annex II will be regarded as affiliated companies of buyer. Article 3. Term and conditions precedent. 3.1. This agreement is effective from the effective date and continues in full force and effect, until terminated pursuant to this agreement or the general terms and conditions. 3.2. Prior to any obligation on the part of seller to sell fuel under this agreement, or on the part of buyer to purchase fuel under this agreement, all conditions set forth in this Article 3 shall be satisfied by seller, or with respect to subsections 1 and 2, waived by seller, with respect to subsections 3 and 4, waived by seller and buyer. 1. Seller shall have reached a final investment decision with respect to one or more seller facilities, as defined below, no later than December 31, 2023. 2. Seller shall have obtained funding to construct the seller facilities by June 1, 2024. 3. Seller shall have obtained all governmental authorizations for development of seller facilities and production and delivery of fuel as required by the location agreement, including all necessary approvals to supply to the applicable delivery points, and shall have provided written notice of the same to buyer. And 4. The commencement date, as defined in the agreement, has occurred no later than July 1, 2026. Seller shall work in good faith to achieve the above conditions precedent by the applicable deadline. Notwithstanding anything to the contrary herein or in any location agreement, if the conditions set forth above have not been satisfied or waived on or before the applicable deadline, either party shall have the right to terminate this agreement and any location agreements thereunder, without any liability of buyer or seller arising from such termination, on not less than 30 days prior written notice to the other party. 3.3. From and after the commencement date, seller shall be obligated to deliver the fuel as per the provisions hereof and the applicable location agreement. As used herein, commencement date means the date specified by seller in a written notice to buyer furnished not less than 60 days prior to such date that the first seller facility has achieved commercial operation and is able to produce and deliver the fuel as set forth in this agreement. 3.4. Seller shall keep buyer reasonably informed as to the status of seller's development and construction of seller facilities required for the achievement of the commencement date, including providing regular updates, not less frequently than quarterly, commencing no later than 1 year prior to the expected commencement date. 3.5. As used herein, the following terms shall have the respective meanings. Seller facility or seller facilities means the facility for production, refining, and delivery of fuel capable of producing up to 75 million gallons of fuel per year, to be developed and constructed by seller, at its sole expense and identified in a notice to buyer at least 120 days prior to each such facility being capable of producing all or a portion of the aforementioned gallonage. Article 4. Location Agreements. 4.1. All specific terms and conditions relating to the supply of fuel agreed between buyer and seller for any given location during a certain period of time shall be detailed in a location agreement, hereinafter, each a location agreement. 4.2. Seller and buyer agree that all obligations of buyer under a location agreement to purchase fuel shall be on a take or pay basis, such that buyer shall pay for and receive, or cause to be received by a third party, or pay for even if not taken, all fuel tendered by seller to buyer at the delivery point under a location agreement, on condition that, in tendering such fuel, seller has complied in all material respects with its obligations hereunder and subject to the conditions herein, including without limitation with all specifications stipulated for the fuel, its blending and blended output. Upon refusal by buyer to accept any fuel tendered by seller per the preceding sentence, buyer shall have relinquished any rights thereto. 4.3. Upon the parties having reached agreement on the specifics of any such location, buyer shall forward a fully complete location agreement to seller. For purposes of clarity, unless otherwise agreed in a location agreement, all deliveries of fuel shall be as specified in section 7.1. Upon receipt of a location agreement, seller may reconfirm the agreement by either, at seller's option, 1. Countersigning the location agreement and returning the document to buyer, or 2. Giving other written notice of reconfirmation. 4.4. Each location agreement shall form an integral part of this agreement. 4.5. A location agreement becomes effective on the first day of the delivery period as stated therein. The expiry date of the location agreement shall be the last day of the delivery period, or, in case of early termination in accordance with this agreement or the general terms and conditions, the day of such early termination. 4.6. Unless otherwise set forth in a location agreement, the initial term of each location agreement shall commence on the commencement date and continue until the 7th anniversary of the commencement date, initial term, at which time the term of such location agreement shall automatically renew for an additional 3-year period unless either party shall have elected to terminate such location agreement as of the 7th anniversary of the commencement date by providing at least 6 months prior notice to the other party of such election, each, a renewal term, and together with the initial term, the term. If such location agreement is the only location agreement in effect between the parties at the time of such termination, The terminating party shall also be permitted to terminate this agreement concurrently with the termination of such location agreement. For sake of clarity, no such termination shall relieve a party of obligations that have accrued under any such agreement prior to the termination thereof. Article 5. Pricing. 5.1. Pricing under all location agreements shall be as set forth in this Article 5. Prices set forth in this Article 5 are exclusive of the value associated with emissions credits. The allocation of such value shall be governed by Section 6 below. 5.2. A. Unless a location agreement specifies a different price, the price for fuel sold to buyer hereunder will be confidential fuel price. B. Confidential. C. Confidential. 5.3. The pricing set forth in Section 5.2 shall be fixed until the end of the initial term, confidential. Commencing on a renewal term, the price applicable to any deliveries or deemed deliveries of fuel hereunder shall be as may be mutually agreed by the parties to a location agreement. 5.4. Delivery and blending costs shall be payable as set forth in Article 7. 5.5. After the commencement date, buyer shall not, at the close of any business day, permit the sum of 1. The aggregate amount of unrestricted cash and cash equivalents, and 2. The aggregate principal amount committed and available to be drawn by buyer under all revolving credit facilities of buyer to be less than, confidential, the liquidity threshold. If buyer falls below the liquidity threshold, seller may require buyer to prepay for any subsequent fuel to be delivered under a location agreement 60 days in advance of such fuel delivery, or such shorter period as agreed in seller's sole discretion, until buyer is no longer below the liquidity threshold. 5.6. Confidential. Article 6. Allocation of production emissions credits and confidential. 6.1. Confidential. 6.2. Within 30 days following the end of a calendar quarter during the term, confidential. Any amounts due and owing from seller to buyer shall be reflected as a credit on the next invoice issuable to buyer, provided that if such an amount becomes due and owing after the final settlement of all amounts payable by buyer hereunder, seller shall pay such amounts to buyer. 6.3. Subject to Section 5.7 in Annex I, if any applicable law is enacted, implemented, modified, amended or revoked so that the implementation of the agreement becomes impossible, impracticable or materially inconsistent with the terms or requirements of this agreement and or the general terms and conditions, including any changes to government programs associated with the production emissions credits, the availability of user-specific credits, or in the event of implementation of a carbon pricing law, rule or regulation. If the eligible fuel fails to meet the CORSIA sustainability criteria set forth and published by the International Civil Aviation Organization, the parties shall work in good faith to amend the agreement to conform to the changed requirements or circumstances in order to maintain the original intent of the parties hereunder and the economic conditions set forth herein. Article 7. Delivery and seller's responsibilities. 7.1. All deliveries of fuel shall be to one of the following terminals, as defined below, specified by the buyer. Confidential. Seller may request fuel be delivered to an alternative terminal facility so long as such alternative terminal has a pipeline connection from such terminal to a major airport, alternative terminal, subject to buyer's written consent. Confidential. 7.2. As used herein, the following terms have their respective meanings as set forth below. A. Confidential. B. Confidential. C. Confidential. D. Terminals means, confidential. 7.3. Delivery shall occur, confidential, the delivery point. From and after the effective date, seller represents and warrants that, confidential, has a direct pipeline connection to a United States major airport. 7.4. Seller shall, on buyer's behalf, and in accordance with this agreement, applicable laws and applicable industry standards, provide, or cause to be provided, 1. Transportation to the delivery point of all quantities of fuel made available hereunder to buyer and, 2. Storage and blending of the fuel with conventional jet fuel prior to delivery to the delivery point. All costs incurred from the seller facilities up to the delivery point, the delivery and blending costs, shall be for the account of seller. As of the date hereof, the parties anticipate that the following will be included within the delivery and blending costs. 1. The cost of transportation between the seller facilities and the delivery point. 2. Storage costs at the applicable terminal facility. And 3. Blending costs at the applicable terminal facility, including expenses to secure permissions and authorizations needed for the blending of the fuel with conventional jet fuel. 7.5. Seller shall further be responsible for securing all permissions and authorizations needed for the blending of the fuel with conventional jet fuel and for the conduct and output of such blending according to the standards and specifications agreed herein. Without prejudice to the generality of the foregoing and without the scope of the foregoing being deemed reduced, seller shall also be responsible for securing recertification, approval of the blended output, including product gains recertification, after blending. 7.6. Should delivery for fuel purchased by the buyer not be due to the buyer, but a third party or affiliate designated by the buyer, seller's obligations hereunder shall also apply for such delivery. Article 8. Minimum annual contract quantity. The minimum annual contract quantity shall be, a. From the commencement date until the first anniversary of the commencement date, the volume of fuel seller is able to produce and deliver to buyer on an as available basis, but in any event, no greater than its obligation under subclause b, and b. From and after the first anniversary of the commencement date, 75 million gallons of fuel per year, delivered monthly on a pro rata basis, in the aggregate from the seller facilities, or if seller is unable to produce a total of 75 million gallons per year, the amount of fuel actually produced by seller. As set forth in Section 4.2 and Section 5.2, seller shall sell and deliver, or cause to be delivered, and buyer shall purchase and receive, or cause to be received, at the delivery point, or pay for even if not taken, the minimum annual contract quantity of fuel per year, beginning on and continuing after the commencement date through the initial term, provided, however, that if the term is renewed for a renewal term, such obligation shall continue through such renewal term. Subject to Annex I, Section 5.5, seller shall adhere to the delivery schedule agreed in writing between the parties. Until such time as seller has sold out the capacity of seller facilities, seller may, in seller's sole discretion, offer to buyer the option to purchase additional gallons of fuel in excess of the minimum annual contract quantity from seller on the same terms and conditions as set forth in the agreement. Buyer may meet the minimum annual contract quantity requirement through one or more location agreements. As used herein, 1. As available basis means that seller, in its sole discretion, has fuel available for sale from the seller facilities for supply to buyer, and 2. The term gallon as used herein shall mean a U.S. gallon of 231 cubic inches and the term barrel shall mean 42 U.S. gallons, both corrected for temperature to 60 degrees Fahrenheit in accordance with ASTM D 1250 Petroleum Measurement Table 6b, unabridged as most recently revised from time to time, or the American Petroleum Institute Standard 2540/ASTM D 1250/IP designation 200, whichever is in use at the discharge terminal, unless otherwise specified in the agreement. Article 9. Invoicing and payment terms. Unless otherwise agreed in the location agreement, the following shall apply. 9.1. Seller shall issue an invoice for each shipment of fuel tendered for delivery to buyer under the applicable location agreement, which shall contain the following information: a. The volume of fuel in the applicable shipment. b. The price per U.S. gallon of fuel. c. A description of applicable taxes, fees or other charges. d. Total amount due on the invoice. e. The date of the shipment, and f. The delivery note reference. A delivery note must accompany each invoice. 9.2 Invoices shall be sent via email to, confidential. 9.3. Invoices for fuel delivered or deemed delivered to companies for which buyer is acting as an agent only shall be sent directly to the agreed company without any involvement of buyer, unless otherwise directed by buyer in advance in writing. 9.4 Unless otherwise specified in the respective location agreement, invoices shall be issued and payment shall be effected in United States dollars. 9.5. The payment terms shall be as follows. A. Payment by buyer on each invoice shall be net, confidential, from the date of issue of an invoice complying with the requirements of sections 9.1 and 9.2 above. Payment shall be made by wire transfer of immediately available funds in United States dollars. Details about the seller's banking information are set forth in section 9.6 below. B. Absent manifest error, buyer shall pay all disputed and undisputed amounts due under each invoice without netting or offsetting. In the case of manifest effort, the correct amount shall be paid disregarding such error, and necessary correction and consequent adjustment shall be made within 5 business days after agreement of the correct amount. C. If a party invoiced and received payment of a sum subsequently determined not to have been payable under this agreement, such party shall pay interest to the other party on such amount on and from the date when such sum was originally paid and including the date of its repayment at a rate, the interest rate, equal to, confidential. Any amount not paid by a party when due shall bear interest from and including the date payment was originally due to and including the actual date of payment at the interest rate, confidential. 9.6. Payments shall be transferred to the seller's bank account as provided for in the applicable invoice. Article 10. Insurance. 10.1. Until all obligations under this agreement are satisfied, and without limiting seller's indemnification obligations under the agreement, seller shall procure and maintain the following insurance policies from insurers with an AM Best rating of B+ VI or a comparable rating. A. Workers' compensation covering obligations imposed by federal and state statutes with jurisdiction over seller's employees and employer's liability insurance of at least, confidential. B. Commercial general liability insurance with a minimum limit of, confidential, per claim for bodily injury or death and broad form property damage. The policy shall cover bodily injury, property damage, personal injury, products and completed operations, and broad form contractual liability coverage including, but not limited to, the commercially insurable liability assumed under seller's indemnification obligations set forth in the agreement. C. Business automobile liability insurance with a limit for bodily injury and property damage of a minimum limit of, confidential, each occurrence with respect to any and all vehicles of sellers, whether owned, hired, leased, borrowed, or non-owned, assigned to or used in connection with seller's performance of the agreement, and D. Environmental impairment liability insurance with a limit and annual aggregate of, confidential, which shall include coverage for all actions, omissions, or active or passive negligence, for bodily injury, property damage, defense costs and environmental remediation costs with respect to releases of hazardous substances at the seller facilities, including fuel prior to delivery. 10.2. Additional insureds. Except for workers' compensation, all the policies required in this Article 10 shall name buyer and its affiliates as an additional insured whether in its/their capacity as buyer or as a reseller of the fuel. 10.3. Primary. The policies shall stipulate that the insurance required by this Article 10 shall be primary insurance and that any insurance or self-insurance carried by Article 11. Governing law. The validity, construction and performance of this agreement shall be governed by New York law without giving effect to any choice of law provision or rule, whether of the state of New York or any other jurisdiction, that would cause the application of the laws of any other jurisdiction. Article 12. Disputes. The parties shall attempt to resolve any disputes under this agreement through negotiation prior to resorting to other dispute resolution mechanisms. If the parties are unable to do so after using reasonable good faith efforts, the federal or state courts situated in New York County, New York, United States of America, have exclusive jurisdiction over the resolution of all disputes that arise under this agreement, and each party irrevocably submits to the personal jurisdiction of such courts. The United Nations Convention on Contracts for the International Sale of Goods shall not be applicable to the parties' rights or obligations under this agreement. Article 13. Financing cooperation. Without diminishing seller's obligations and buyer's rights hereunder, buyer acknowledges that seller may elect to finance all or part of its costs of the transactions contemplated by this agreement, including the costs of the construction of seller facilities. Buyer shall use commercially reasonable efforts to provide all cooperation reasonably necessary in connection with any financing efforts that seller may undertake in connection with financing seller facilities, as may be reasonably requested by seller, provided that such efforts shall not a. relieve seller of any of its obligations under this agreement, b. decrease the economic benefits, or increase the costs, of the transactions contemplated by this agreement to buyer, or c. create increased economic or legal risk to buyer in connection with the transactions contemplated by this agreement. In furtherance of the foregoing, buyer agrees that it will not unreasonably withhold its consent to a customary collateral assignment for security purposes of this agreement for the benefit of such persons providing such financing, which such collateral assignment shall be in form and substance reasonably satisfactory to buyer, as may be reasonably necessary and appropriate for such financing, provided that none of the terms of such consent shall, 1. relieve seller of any of its obligations under this agreement, 2. decrease the economic benefits, or increase the costs, of the transactions contemplated by this agreement to buyer, or 3. create increased economic or legal risk to buyer in connection with the transactions contemplated by this agreement. Article 14. Assignment. 14.1. Neither party may assign its obligations under this agreement, in whole or in part, without the prior written consent of the other party, provided that such consent shall not be unreasonably withheld, conditioned or delayed. Confidential. Either party may, however, assign its obligations to any affiliate of such party without the prior written consent of the other party, provided that in such event, but subject to section 14.2 below, the assigning party shall be jointly and severally liable for the performance by such affiliate of the agreement. 14.2. Notwithstanding the foregoing, seller may, without the prior written consent of buyer, a. Assign this agreement to any person acquiring all or substantially all of the assets comprising any seller facility. B. Collaterally assign this agreement to any person providing financing or other security in connection with any seller facility, or C. Assign this agreement to any special purpose vehicle in connection with the financing. Provided, however, that if the assignment or transfer under this section 14.2 is a. Confidential, seller shall obtain buyer's prior written consent. With respect to any assignment pursuant to sections 14.2a or 14.2c, the assigning party shall be released from all obligations and liabilities under this agreement provided that buyer shall have no greater overall liability, obligation or costs or any diminution of rights under this agreement. Article 15. Public announcements. Neither party will, without the other party's prior written consent in each instance, a. Use in advertising, publicity or marketing communications of any kind the name or other trademarks of the other party or any of its affiliates, or any employee of either, or b. Represent, directly or indirectly, that any product or service provided by a party has been approved or endorsed by the other party or any of its affiliates. Notwithstanding the foregoing, seller and buyer agree to publicly disclose, via a mutually agreed upon press release, aspects of the commercial plan for buyer to serve as a purchaser of fuel from seller facilities at such time as seller and buyer shall mutually agree at their respective unfettered discretions, save that, as a condition precedent for such disclosure/publication, each party shall coordinate with and shall receive the written consent of the other party with respect to such disclosure/publication, and shall so provide advance copies to the other party for review of the text of any proposed announcement/publication prior to the dissemination thereof to the public or to any person other than employees, consultants, representatives, agents, advisors, contractors or subcontractors of any tier, who agree to keep such information confidential. Notwithstanding the foregoing, either party shall be permitted to make any and all required disclosures of the agreement and the transactions contemplated thereunder in accordance with the rules and regulations of the U.S. Securities and Exchange Commission, SEC, including, but not limited to, filing the agreement with the SEC in connection with a Form 8-K, 10-Q or 10-K, albeit to the extent that may be so required, subject to the right of the other party and its counsel to review copies of any such proposed filing or filings in advance thereof and comment thereon, and the obligation of the disclosing party to accept any comments reasonably requested by the non-disclosing party or its counsel with respect to the description of the disclosing party in such filing or filings or with respect to the redaction of trade secrets or competitively sensitive information contained therein. Article 16. Counterparts. This agreement may be executed in multiple counterparts, each of which when so executed and delivered shall constitute a duplicate original and all counterparts together shall constitute one and the same instrument. Buyer shall only be bound by this agreement upon its execution and return of such executed counterpart to the seller. The parties acknowledge and agree that any document or signature delivered by facsimile, PDF or other electronic transmission shall be deemed to be an original executed document for the purposes hereof and such execution and delivery shall be considered valid, binding and effective for all purposes.